Welcome to Chapter 16. We're looking at civil rights. And if you remember from U.S. history class, the civil rights movement, check Google Classroom for the link to the American Century video, a great one to watch if you have time on the civil rights movement, if you need some background on that. But these are the notes for Chapter 16. First of all, let's talk about the requirements for citizenship. This idea of birthright citizenship actually came from the 14th Amendment. The idea of a citizen being naturalized really is enumerated here in terms of the requirements. You've got to be 18 or older. You've got to be a permanent resident of the United States for at least 5 years. You need to file a petition. You need to be able to speak English, write and read it, as well as have good moral character. Again, that's interpreted by the Naturalization Office in terms of what they do there. There is a citizenship test that you take as part of this, understanding the history and background on government, that sort of thing. And I've had students in government class that have taken that citizenship test after having the government class. They have to, over the last 10 years, advocate for the support of democracy and a democratic form of government, essentially, not to have organized any type of demonstrations or violence, riots, or been involved in any of that sort of thing, and have good legal standing. That's really the background on it. But the question of birthright citizenship really came about with the 14th Amendment, and the Supreme Court has upheld that as being under the Equal Protection Clause, the Citizenship Clause, has been a right that if you are born in the United States, born of American parents in the United States, you are you are a birthright citizen of the United States. So, do legal resident aliens have any rights? Well, they do. Again, it depends on who's in office, and it depends on the type of situation that they're in, and what the courts may rule. But citizens are the ones who can vote and run for office. Now, that is changing. Places like Garrett Park in the Montgomery County area that have allowed non-citizens to vote in local elections. We've seen some of that with non-citizen ID cards in California and so on. So there are rights that are related to that, but all people have free speech rights, freedom of religion, and due process, of course, under the law. And again, enemy combatants after 9/11 were under certain requirements that were different from that, but that's essentially where that comes from. So let's look at the background of the civil rights movement. In 1877, we know Reconstruction ended with the election through the Electoral College of Rutherford B. Hayes. Samuel Tilden won the popular vote, but Hayes agreed to end Reconstruction, and therefore the Electoral College went his way. In terms of the Electoral College vote, there was definitely a white power structure here, and this is when we start to see a lot of the Jim Crow laws and the black codes of the South begin to take new life. And unfortunately, the northern leaders and those in power in the North did not a whole lot of anything, and many of those just exacerbated the problem with segregation. And really kind of looked the other way, or in many ways by not saying anything, they really did perpetuate the type of white supremacy that was going on in the country at the time. So fast forward about 100 years to the early 1950s, we start to see Brown versus Board of Education, the picture on the left here, ruling that was a unanimous ruling overturning Plessy v. Ferguson, basically stating that segregation was unconstitutional. It was not the law according to the Constitution. And we really started to see this prior to this case, but this is really the turning point. African Americans began advocating in the 1930s. We saw this with the Roosevelt administration during the Great Depression. And Truman really brought this about in 1948 when he desegregated the military. Then Brown would come along not long after that, and Eisenhower, now the president in 1954, would have to enforce it, which would lead to Brown 2, the Brown v. Board of Education 2, in our landmark cases that basically said, not only do you have to enforce this desegregation because segregation is unconstitutional, you also have to do it with all deliberate speed. which was the phrase they used, quote, with all deliberate speed. And the idea was, don't dilly-dally, don't take your time, don't think that this is a 10-year process, just do it, and do it now. And that essentially is what led to the Montgomery bus boycott happening in Alabama as well in 1955, and a number of things that really promulgated and really set the stage for the civil rights movement that would take off from there and expand over the next 10, 12, 13 years until the death of Martin Luther King Jr. So we had the Civil Rights Act, a significant piece of legislation that Dr. King was advocating for with the Kennedy administration. Kennedy did not had the vision for it, but did not have the opportunity to get it passed. Lyndon Johnson, his vice president, who becomes president during after his assassination, basically says, "Let's do this on behalf of the president. Let's do this in his honor and in his name." He had the dream to do this. Let's in terms of what Dr. King had laid out for him. So let's do this and do it in honor of our slain president. And he was able to get it passed. Now, what's significant about this Civil Rights Act versus the many, many, many other Civil Rights Acts that were passed since 1877? The difference is this one had teeth. This one actually had enforcement mechanisms. This one had funds tied to it in terms of what you were or weren't going to get in terms of monies from the government if you were going to get around this. And it really did start to pull the states in line with the National Civil Rights Bill in showing them that it really needed to be followed. And the Voting Rights Act then was a loophole that was created in the Civil Rights Act that allowed them to not allow people to vote. We had polling taxes. We had white primaries if your parents were white. The grandfather clauses, if your grandfather could vote, you could vote. Well, my grandfather was a slave. Well, then you can't vote. That kind of thing. And this led to the Voting Rights Act and what we saw at the Edmund Pettus Bridge in Selma, Alabama, in terms of people advocating for their right to vote. And this turned into Bloody Sunday. The Voting Rights Act, Lyndon Johnson gets on national television and says, we shall overcome. This needs to change. And we need a Voting Rights Act that closes these loopholes. It basically bans poll taxes, bans white primaries, bans grandfather clauses, bans any type of testing in order to be able to vote. Everyone should have the right to vote, and it should be enforced across the board. And that is what would ultimately lead to a more equity in terms of the voting standards. And here's what I just talked about in terms of trying to keep them from voting. The grandfather clause, as I mentioned, was declared unconstitutional in 1915, yet we still saw it around. White primaries, 1944, yet we still were seeing this by the time the Voting Rights Act came along. Poll taxes, definitely, and literacy tests were finally outlawed with the Voting Rights Act. So we saw a lot of this in the southern states, especially. But the idea was the Voting Rights Act basically annihilated it all. It basically took it all out as it should be. The Civil Rights Act of 1964, again, the idea here was to make sure that there wasn't discrimination going on in any types of public accommodations. So we had schools that were desegregated and moving in that direction and trying to make sure that was applied across the board. Now we needed to apply it to hotels and motels and restaurants and gas stations, movie theaters. And the Supreme Court used the Commerce Clause to uphold this and its constitutionality. The Voting Rights Act, as I mentioned, has been renewed. There was a piece of it, Section 4, that was actually declared unconstitutional by the court a couple of years ago. So to be continued in terms of how that plays out. We saw a lot of states passing voter ID laws that would have been legal. It would have been illegal under Section 4, but with the rescinding of Section 4, we saw a lot of southern states that changed that. Yes, even in 2018, we continue to see problems in terms of fairness when it comes to applying the Voting Rights Act, unfortunately. So we still move towards that moving towards justice, but it is an arc. It is not a clear road. Shelby v. Holder was the case in 2013 that basically said that there are states that have to have pre-clearance provisions, and this case basically said no, you don't. The pre-clearance provisions that we've had up to this point for states that seceded from the Union during the Civil War had to be pre-cleared by the Justice Department to make sure that their voting procedures and their voting rights were applicable with the Voting Rights Act, and the Supreme Court basically ruled that unconstitutional. In Shaw v. Reno, this case was from 1993 and basically said you can't draw legislative district lines just based on race. It can be a number of factors, but it can't be the factor. If the intent is to create a majority-minority district, that is still not enough to redraw the district lines solely based on race. And this is what gave way to this idea of cracking. You can't crack up a minority district in terms of their minority voting power. You also can't pack them into one district that gives them more voting power and less voting power in another district. All of these designed to try and keep their voting less representative of the number of people that are representing them, and that was ruled unconstitutional in the North Carolina case. In 1919, women won the right to vote in terms of other civil rights legislation. We also saw this was still denied, though, to legal equal rights in terms of owning property until we get to the 20th century. We also saw a number of other groups that obviously were being discriminated against, minority groups especially, until the 1960s when we saw the Voting Rights Act passed. So women took a long time to get there from the time that they were winning the right to vote in the 19th Amendment. Equal protection. This is probably the big enchilada of the 14th Amendment. There's a lot in there in terms of due process clause, the Equal Protection Clause, the Citizenship Clause, birthright citizenship. Equal Protection Clause is probably the biggie that we hear the most about, because this is really about making sure that no state can deny any person the equal protection of the law. And that's pretty broad. And so there's a lot of things that are governing this. So we saw this with the Civil Rights Act. We saw this with the vote for women in getting the 19th Amendment passed. We saw this with Bergefell v. Hodges and the gay marriage case. We see this with employment. We see this with equal pay for women, a number of cases that use equal protection as their basis. And if you look at the landmark cases sheet, the graphic organizer that we have, you see that there's a number of cases equal protection is the basis for that case, and that comes from the 14th Amendment. And even Gideon v. Wainwright with you have a right to a lawyer. He was denied equal protection under the law that gave those in capital cases a right to a lawyer, but not in criminal cases that didn't involve a capital offense. And so he used the Equal Protection Clause as his basis, and they did rule it unconstitutional that he was allowed a right to a lawyer. All right, the three standards, very important that we understand the differences here. Rational basis is this idea like there is some level of discrimination that is allowed. Progressive income taxes is a good example. The more you make, the more they take. And this is allowable discrimination, basically under a rational basis for doing so, for discriminating from the different types of, for differentiating between the different types of income levels. So if you make more money, they're going to charge you more. And that has been determined by the court to be a rational basis in terms of their standard. Intermediate scrutiny is a little differently. There's a little higher bar there in terms of being allowable under the law. Intermediate scrutiny, a lot of times different laws for men versus women. For instance, those that clean locker rooms at a gym, men versus women. If it's a man cleaning a women's locker room, they need to close it down, and then women can't use the facilities. So they hire a woman to do that job. They hire a man to clean the men's locker room, that sort of thing. And that's more intermediate scrutiny. That has been upheld by the courts. They understand the logic there. It is a little higher bar, but they do understand why that would need to take place. And the last one is strict scrutiny. And this is the highest bar. This is put it in the classification of it's really hard to understand why you would need to discriminate here. And these are what we call suspect classifications, like race, national origin, or religion. You really can't make the case for this, and the chances are that the courts will rule it unconstitutional in terms of any type of law or any type of regulation that you pass that discriminates based on race, national origin, or religion. So age is not a suspect classification, although we have seen it, as I mentioned, as an intermediate classification in terms of that scrutiny. We don't want an 80-year-old man going up on a skyscraper and helping to build a building on the 80th floor. That wouldn't make a whole lot of sense. So there is a legitimate interest in doing so. The same thing has been upheld for driver's licenses. There's a certain age in which people are allowed to drive. Age of consent in terms of drinking, age of consent in terms of other types of participation and drinking ages and so on. So a lot of this is coming from the cases we've talked about. Plessy versus Ferguson, we know, and Brown we just talked about. Loving v. Virginia was interracial marriage that basically was ruled, the laws in Virginia ruled unconstitutional in 1967, again saying it violated the Equal Protection Clause. We saw in 1996 the Virginia Military Institute had a men's-only student body, and a woman sued saying it violated the 14th Amendment Equal Protection Clause. And we saw this was ruled unconstitutional by the Supreme Court. And the latest one we saw was in 2015, in which we saw the Obergefell v. Hodges case, the same-sex marriage case that was also ruled a violation of the 14th Amendment under equal protection. So we continue to see those types of cases, and they're using the 14th Amendment as their basis. So the approval of the 14th Amendment and the Equal Protection Clause after the Civil War really did make a difference, because the significance there is that it really opened the discussion for a larger discussion about discrimination across the country. Fair housing, this came along in 1968. It was a part of the Great Society that Lyndon Johnson was building with the Civil Rights Act of 1964, the Voting Rights of 1965, and now fair housing in 1968. And this, again, was closing another loophole in that law, the Civil Rights Act of 1964, because there were restrictive legislation since 1948 that had been upheld by the Supreme Court, and up to that point. And in 1948, they outlawed it. But unfortunately, as always, there are loopholes in terms of how they can discriminate and steering in one way or another. Oh, you don't want to live here. This house is infested with rats. Oh, this never met building code. Oh, this is. Meanwhile, they'll rent it out or sell it to a white couple. These types of things were ruled unconstitutional, and the idea of the Fair Housing Act in 1968 really helped to close a lot of those loopholes. So a lot of it ended with Brown versus Board of Education in terms of that separate but equal. But you can see there was a lot of other things that needed to be passed in order for it to take effect, such as the Civil Rights Act of 1964, Voting Rights Act of 1965, the Fair Housing Act of 1968. But keep in mind that de facto segregation is worse today than de jure segregation. So what are those? De facto is kind of in fact how it plays out in the real world. De jure is more by jury or by law in terms of what we saw in 1954 with the Supreme Court ruling Brown v. Board was unconstitutional, separate but equal. But today, what do we see? We see a lot of communities, neighborhoods that are very segregated, segregated by class, but also segregated by race, segregated by income, segregated by ethnicity and other aspects. So de facto segregation, and Magleby talks about this in more detail, is worse today than ever than we saw in the de jure segregation in 1954. And this leads to affirmative action conversations and led to, in the 1970s, a lot of affirmative action laws that led to Bakke, the University of California v. Bakke case of the white student who was applying to the University of California Medical School and said he was discriminated against because he was white, and the Supreme Court ruled it unconstitutional under the 14th Amendment, the Equal Protection Clause. So we started to see those affirmative action results there. But Lyndon Johnson, as part of his Great Society, he really highlighted this in saying, how can you not call for some type of affirmative action? Freedom is not enough. You do not take a person for years who's been hobbled by chains and liberate him, bring him up to the starting line of a race, and then say you're free to compete with all the others, and still justly believe you've been completely fair. And that was his point, was how can you really look at that and say that wasn't that was fairness. If they don't have a level playing field to start from, then that's a problem. And that was the basis for the 1954 case in Brown. How can you say that she has a fair starting point when you send her to an all-black school and she walks right past a white school in order to get to that school? How is that equal protection under the law? And it was a unanimous case telling us that it was the entire court that agreed to reverse this decision. Here's the Bakke case I mentioned. This was an idea of reverse discrimination, and the Supreme Court ruled that he was correct. The school was unconstitutional in adhering to affirmative action quotas, and basically said the quotas that discriminated against him. And so as a result, even though his test scores were higher and he didn't get in, this was a violation of the U.S. Constitution under the Equal Protection Clause in the 14th Amendment. So they said quotas cannot be used moving forward. Race can be a factor, but not the factor. And we saw this in the Gratz and Grutter cases. In the Gratz case, and you can remember Gratz and Grutter because they're both University of Michigan cases, but the difference is Gratz is for the undergrad. That's for the freshmen coming in. And here, the idea was, they said race could, in terms of diversifying the campus, that they could use it as a factor but not the factor. In Grutter, they said we understand why race would be a bigger factor in terms of helping to diversify your student body. Under Gratz, you have a much larger admission process in terms of having to address that. So that, in a nutshell, is kind of where we've come in terms of using affirmative action. So the quotas, unconstitutional. We see it more in law school, in grad school, where they're trying to diversify their student body, and there's a much smaller pool of candidates to pull from. In Gratz, they said it can be a factor but not the factor in the undergrad ruling, but the idea there was you couldn't use quotas in terms of affirmative action because it violated Equal Protection Clause. So that was the significant piece here, was that it couldn't be any overwhelming of a factor more than student test scores, more than extracurricular activities, more than your essay, more than your recommendations or anything else. It was a factor among many other factors in which you were determined to be a future incoming student. So today, what do we see? We still continue to see problems in civil rights when it comes to legal barriers. Many of them have been removed, but we have a long way to go. As we can continue to see in the news every day, there are always going to be problems that we're going to have to stand up and take a look at and say, wait a minute, what's going on here? We see the achievement gap. We see the socioeconomic gap. We see the issues in job training and access to college and access to money for college. All of those things are civil rights issues. All of those things we are trying to address, and we're doing a better job of it, but we still have a long way to go. So in looking at the key provisions of these civil rights bills, as I mentioned, 1964 is a biggie because that's the Civil Rights Act that really addressed voting, public accommodations, schools, employment, and federal funds. As I mentioned, you take away the funding, you have teeth, you can enforce it. 1965, we see this with voter registration, outlawing literacy tests and poll taxes. In 1968, we saw this with housing, banning it based on discrimination. And we saw in 1972 with Title IX, making sure that sex discrimination was unconstitutional. All of these continue to chip away at trying to make the United States a more equitable and more equality-based country based on civil rights laws and based on the U.S. Constitution. And that's all we've got for this chapter. We hope you enjoyed Chapter 16. Do check out the top 12 highlights from Chapter 16 where you'll get more information. But I'm Mr. Rodman, and I hope you live the 5. Have a great day.